All right, welcome to today's meeting, March 9th, 2023 of the Washington State Gambling Commission. We are in person. We have all four of the commissioners here at the Washington State Liquor and Cannabis Board, and we are starting at 9:35. Today's meeting will be recorded, and so I'm going to call the roll. We know that we have commissioners, so is Senator Conway here? Representative Kloba? Senator Holy? Or Representative Root? All right, I'm not seeing any of them. If you have any questions regarding the meeting, please contact Julie Anderson at julie.anderson@wsgc.wa.gov. The telephone lines are currently muted. When I ask the public comment, please unmute your line, provide your comment, and then remute your phone. And please do not interrupt individuals who are speaking during the comment period. When you provide public comment, please clearly state your name, your contact information, if you'd like to receive a summary of all comments, and who you are representing. So now we will go into tab 1, which is the consent agenda for the February 9th meeting minutes, the new licensees and Class 3 employees, electronic raffle report, manufacturer's report, and non-profit officers working in multiple organizations. Are there any comments or questions about that from the commissioners? Is there any public comments? Not seeing any. Is there a motion?
I move to approve the consent agenda.
Thank you.
Second.
All right, it's been moved and seconded. Is there any further discussion? All right. All those in favor say aye.
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 Aye. All right, that motion has been moved and passed. Next up is tab 2, which is a petition for review with, I hopefully say this name correctly, Shan Malati Touch, case number CR 2021-01221. And that will be done by Assistant Attorney General Doug Vanderbrake and attorneys for the petitioner Frank Hugenin, apologies again, and Jeffrey Carl. With that petition for review, there was a motion to strike filed by Mr. Vanderbrake. And I'm going to let Matt Kermit, our AAG, kind of explain that process, as the commissioners did not get that, I don't believe so.
Yes, though this motion will be distributed to the commission. This was a motion to strike filed by commission staff of certain exhibits filed by the petitioner here. This proceeding is before the commission as a review of an initial order. And so, in part of the appeal, petitioner submitted certain exhibits for consideration that were not included in the record for OAH, the Office of Administrative Hearings. So the motion to strike is specifically dealing with that issue about whether or not the commission, in reviewing the initial order, can consider those extra filed exhibits. That is so that is the situation here. We have a motion to strike as well as the review of the initial order.
So we're going to hear the motion to strike first, and then we can go into closed session if need be, rule on that, and then come back and hear the actual petition for review. And I am going to ask Matt one more question. Just
Yes.
What do you think is a proper oral argument time limit for a motion to strike?
Generally, about 5 minutes would be enough.
Okay, that's what I was going to say, but just wanted to make sure I wasn't. So we will go ahead and start with Assistant Attorney General Doug Vanderbrake for your petition motion to strike. And you will have 5 minutes, so I will set a timer now.
Thank you, commissioners. My name is Doug Vanderbrake. I'm an Assistant Attorney General representing commission staff. The basis for the motion to strike is that the evidentiary hearing, which lasted 9 days, provided ample opportunity for the parties to submit exhibits and witness list. And despite the ample time and opportunity to do so, and including an extension the judge granted to Mrs. Touch to file exhibits, she simply never did so prior to the hearing. And then during the hearing, at no point during the hearing did Mrs. Touch offer to admit any exhibits for the record. And the judge noted that in the initial order, Mrs. Touch did not offer any exhibits. So now on the petition for review, Mrs. Touch submitted exhibit A and B. Exhibit B contained 16 subparts. So essentially they submitted 18 exhibits that are not part of the record, were not part of the record before the administrative law judge throughout the evidentiary hearing, and should not be considered for that reason on a petition for review of the initial order. It simply doesn't, it's not part of the record for review. And we respectfully request that those 18 exhibits be stricken and not be considered for purposes of the petition for review of the initial order. Thank you.
Thank you, Mr. Vanderbeek. Now we'll move on to the attorneys for the, or Mrs. Touch. You will also have 5 minutes.
Thank you. It's just Francis Huguenin here for the appellant Chanmalati Touch this morning. Mr. Carl was unable to be present. I wanted to inquire upon the commission as to whether or not it received the responsive rebuttal materials that were submitted yesterday afternoon in regards to both the motion to strike as well as the reply from the commission staff.
Didn't see it.
That is just now being distributed to the commission.
All right. In light of that, because I do think that it touches both on the response to the motion to strike as well as the petition for review, I would appreciate that my client, who I just appeared for in the context of this petition review, I was not involved with the evidentiary hearing whatsoever, be afforded an opportunity for the commission to make an informed consideration of the presentation. And so I would request that this hearing be continued to the next commission time slot so that way they have an opportunity to review the materials.
Mr. Vanderbeek, do you have an objection to that?
Yeah, staff objects to a continuance of this matter. They filed the petition for review with 18 exhibits. Again, Mrs. Touch was represented by counsel throughout the evidentiary hearing. Ample opportunity to present exhibits and never did. There were 9 days of testimony. Okay. Now she's filed a petition for review with 18 exhibits, and then shortly after about 4:30 p.m. yesterday, filed a reply to the response to staff reply to their petition for review. That should not be considered either, and there is no sound reason for continuing this for the purpose of deciding whether to continue, whether to consider 18 exhibits that are simply not part of the record. The commission is here to review the record from the evidentiary hearing and the findings and conclusions that the administrative law judge issued as a result of the evidence and testimony that the judge heard during those 9 days. It is not to consider 18 exhibits that were never part of that proceeding. So we object to a continuance of this matter.
May I provide a
First.
so,
One minute, please. Commissioner Sizemore.
So I guess, and this may be to our council, I'll refer to our council first, I guess, and then potentially to the 2 representing attorneys. First of all, I'm glad I haven't seen anything yet as far as these new exhibits. So maybe a 2-part question. It almost feels to me inappropriate for 18 new exhibits for us to consider at this point when we are doing a review. So I guess first of all, is it even appropriate for us to see those things at this juncture, based on where we are? And my second question would be, if the commission upholds the initial order, what are the options available to the petitioner?
So, sorry. So in relation to the second question, the options for the petitioner set forth in the Administrative Procedures Act, should the commission decide to uphold the initial order either now or at another date in the future, there are appeal rights to the Superior Court set forth in the Administrative Procedures Act available to the petitioner.
So on that, at that time, can new materials be considered at Superior Court level?
The Administrative Procedures Act does authorize a Superior Court judge to consider those based on the Superior Court judge's determination, but it's for very limited purposes, and generally does not happen.
Okay. You're not going to stab at the first one?
Can you repeat the first one? I apologize.
Is it even appropriate for us to have those new exhibits in front of us as we're considering the review? Or,
That is something that we would discuss in closed session.
okay, thank you.
I was gonna recommend to go to closed session unless someone has something else. Is that?
It's all yours.
Okay, yes, so I think we'll take a break and go into closed session and then come back and maybe have more questions or, yeah. Okay,
So Madam Chair, before we go, do we know how much time each side still has on this?
well, Mr. Huguenin still had about 4 minutes and Mr. Van de Break maybe has about 30 seconds.
Okay, I'm just curious.
Well, Your Honor, or excuse me, I apologize, Commission. I only made argument as to the request for continuance to review the material that was submitted yesterday afternoon. I did not actually make a substantive argument with respect to that. It's actually in the material that was submitted yesterday afternoon. And so that's part of the reason why I want the commission to consider the continuance, so that way they can see my client's response to the motion to strike, as well as the rebuttal to the WSGC staff's reply. And so that's really what is before. First, I've put together a motion to continue this matter in toto. I have not put in forward any argument against the motion to strike.
Yes, I understand that. We're going to go into closed session to figure out the continuance or not. And then if we decide on that, then we'll come back and either hear arguments on the motion to strike or continue it.
Thank you very much, Madam Commissioner.
Could be a 3-part deal. We'll see how it goes. So we're going to go into closed session in a room next door and we'll be back shortly.
You guys get to stay here.